Hello and welcome to SANDEMY.
This series explains housing law, standards, and the Renters' Rights Act in clear, accessible language without getting lost in legal jargon or headlines.
We're not here to give legal advice or take sides.
Instead, we focus on how the housing system actually works in practice for tenants, landlords, letting agents, and local authorities.
In this episode, we're looking at when does the Renters' Rights Act start, timelines, transition, and how to prepare.
This is end of this series, and next series will focus on the guidance for landlords and agents.
Note that we are now February 2026.
It is good to be here for the finale of this series. And highlighting the date is crucial because we are speaking in February 2026. The Renters' Rights Act received Royal Assent back in October 2025. But as many listeners will have noticed, the law didn't change overnight.
That is actually the first thing I wanted to clear up. We've had this strange limbo period. The headlines back in October were screaming, the act has passed, and yet here we are.
4 months later.
Exactly. And people have been carrying on largely as normal. So why the delay? It feels like the government pushed the button, but the engine didn't start.
It's a common misconception.
Yeah.
In legislation, especially with something this structural, Royal Assent is just the permission to start, not the starting gun itself. It all comes down to a thing called commencement.
Commencement.
You just can't overhaul the entire housing market on a Tuesday afternoon without causing, well, chaos. So the government adopted a roadmap approach.
To sort of switch things on in stages.
Precisely. The sector letting agents, landlords, the courts, and councils, they all needed a buffer period to update their systems and, frankly, to just get their heads around the new rules.
So we've been in the planning phase, but looking at the sources and the timeline, we are very clearly moving out of planning and into action. The roadmap seems to be split into 3 distinct chunks. Can you give us the high-level view?
Absolutely. It's structured logically, effectively, by priority. Phase 1 is the tenancy system itself, the legal relationship between landlord and tenant. That's the biggest shift.
Okay.
Phase 2 involves the digital infrastructure things like the database and the ombudsman. And then phase 3 focuses on property standards. But right now, sitting here in February 2026, the only thing anyone is really talking about is phase 1.
Because phase 1 is imminent, let's look at the calendar. When does the switch formally flip?
The critical date, the one you need to circle in red, is the 1st of May 2026.
May the 1st.
That is the go-live date. That represents the start of the new tenancy regime for the private rented sector.
Okay, let's walk through what actually happens when we wake up on that morning. The headline everywhere is the death of Section 21.
Correct. From that date, no-fault evictions are abolished for the private rented sector. Section 21 has been the standard mechanism for ending a tenancy since the late 80s. A landlord could serve a notice, and providing the paperwork was in order, they didn't need to give a reason.
And now?
As of May 1st, that power is gone. A landlord can no longer serve a Section 21 notice to ask a tenant to leave.
That is a massive psychological shift for the market. But I want to be clear for the landlords listening, this does not mean you can never get a property back.
Right, no, absolutely not.
It just changes the how.
Exactly. This is not about indefinite security of tenure, regardless of circumstance. It is about moving from no reason needed to valid reason required. This is where the shift to Section 8 comes in.
Ah, okay.
The Act has significantly expanded the possession grounds under Section 8. So if a landlord wants to sell the property or move a family member in, those are valid grounds.
Right.
If there is serious rent arrears or antisocial behavior, they can still regain possession. But, and this is the key difference, they have to prove that specific reason. They can't just use the no-fault route as a catch-all anymore.
So the burden of proof shifts. Now, alongside the eviction changes, the actual structure of the contract is fundamentally changing too. I was reading about the end of fixed terms.
Yes.
This seems like it might be even more disruptive to the day-to-day operations of an agency than the eviction ban.
It is certainly the biggest operational change. On West May 2026, we moved to a system of assured periodic tenancies. The concept of signing a 6-month or 12-month fixed term.
Gone.
It ends. It effectively becomes illegal to create a fixed term. All tenancies will be periodic, rolling from month to month or whatever the rent period is from day 1.
Let's play that out. If I'm a tenant, I don't have to commit to a year anymore. I move in on May 1st. And theoretically, I could leave in July.
Theoretically, yes. Tenants can stay in the property for as long as they want, provided they pay the rent and don't breach the agreement, unless the landlord has a valid ground for possession.
And for the tenant side?
On the flip side, the tenant can end the tenancy at any time by giving 2 months' notice.
2 months. So that's
Yeah.
the new standard notice period for a tenant.
Yes. It gives landlords a bit more certainty than the old 1-month notice, allowing time to remarket the property. But for agents who built their business models on renewing fixed-term contracts every year, well, that revenue stream is gone.
We'll have to see how that settles. Speaking of behavior, let's talk about money. There's been a lot of noise about bidding wars.
Oh, yes.
We've all heard the horror stories. 50 people viewing a flat and the rent gets bid up by 20%. Phase 1 tackles this, right?
It does.
Yeah.
From May 1st, landlords and agents are legally banned from asking for or even accepting offers higher than the advertised rent. This is a hard cap.
So the price on the advert is the maximum price.
It is.
Or even accepting. That's the kicker, isn't it? So if I'm desperate for a flat and I voluntarily say, I'll give you an extra £100 a month.
The landlord has to say no.
Really?
They have to. If they accept it, they're breaking the law. It's designed to stop that artificial inflation of market rents driven by desperation.
And this ties into rent increases, too.
It does. Those are limited to once a year, and landlords have to use the Section 13 procedure that requires giving 2 months' notice of any increase. And regarding upfront costs, rent in advance is now capped at 1 month.
So no more asking for 6 months' rent up front to secure a property.
No, that practice ends. 1 month's rent in advance is the limit.
And just to round out the Phase 1 protections kicking in on May 1st, we have new rules on discrimination and pets.
Yes, and these are about removing barriers. It becomes illegal to discriminate against families with children or those receiving benefits. You can't withhold information or refuse a viewing based on those factors. It's about leveling the playing field.
And the pet request. I know a lot of landlords get nervous about this one.
The default position shifts. Tenants have the right to request a pet. The landlord has a 28-day window to consider that request and cannot unreasonably refuse it.
20 days is not long if you're trying to check insurance policies or...
It's tight. Landlords need to be ready. But unreasonably refuse is the operative phrase. If the head lease of the block of flats forbids pets, that's a reasonable refusal. But a blanket no pets policy, that's gone.
So there's a workaround.
To mitigate the risk, the Act allows landlords to require the tenant to have pet damage insurance.
Before we move on, are there any exceptions to this new universe? Or does every single rental property in England switch over on May 1st?
There is one major carve-out: purpose-built student accommodation, or PBSA.
Okay, so the big dedicated student blocks.
Exactly. Not your typical student house share on a residential street. Those large blocks will not move to this periodic system. They're governed by different regulations. But for the vast majority of private rentals, including student house shares, the new rules apply.
Okay, this is where I want to dive into the transition because this is the part that I think is going to trip people up. We've established that 1st May 2026 is the start date, but housing isn't a blank slate.
No.
If I signed a 12-month contract in January 2026 last month, does that stay on the old rules until it expires next January?
No. And this is the single most important correction we need to make. In the past, when housing law changed, it often applied only to new contracts first. This is different.
How so?
The government has gone for a big bang implementation. The new system applies to both new and existing tenancies from the 1st of May 2026.
Wow. Let that sink in for a second. So I have a contract in my drawer that says fixed term until December. As of May 1st, does that clause just evaporate?
Effectively, yes. Legally speaking, the tenancy converts to the new system immediately. Section 21 is gone for everyone in the private sector on that date. The contract converts to an assured periodic tenancy by operation of law.
That seems like an administrative nightmare. Does a landlord need to rush out and print millions of new contracts on May 1st?
Thankfully, no. That would be chaotic. For existing tenancies, those signed before May 1st, landlords do not need to issue a whole new contract.
So what happens to the old contract?
The existing agreement remains in place physically, but any clauses that contradict the new law, like the fixed term or a ban on pets, simply cease to be valid. The law overrides the paper.
But surely the tenant needs to know that. You can't just have a contract that says one thing and a law that says another.
Precisely. That transparency is crucial. To manage this, the government requires landlords to provide a specific document called an information sheet.
An information sheet.
It's a standard document published by the government that explains all the changes, the new rights, the end of Section 21, all of it.
It sounds simple, but in regulatory terms, this is a compliance trap, isn't it? When do landlords need to serve this?
The deadline is the 31st of May, 2026.
So they have 1 month.
Exactly. The law changes on May 1st, and landlords have exactly 1 month to serve this information sheet to their existing tenants.
That is a very hard deadline, 31 May 2026. And what if they miss it?
It creates a compliance gap. Usually in housing law, failure to serve prescribed information invalidates other notices you might want to serve later, like a possession notice. So you really do not want to miss that date.
And what about verbal tenancies, the casual arrangements?
They're covered too. For any verbal tenancies, landlords must provide a written summary of the terms by that same date, 31 May 2026. The government wants everything documented.
So phase 1 is the urgent part. But the roadmap has a phase 2, this digital infrastructure phase. When does this happen, and what are we actually building?
Phase 2 kicks off a bit later, from late 2026. The centerpiece here is the new private rented sector database.
A national landlord register.
Essentially, yes. A mandatory registration system for all landlords. They'll need to provide contact details, property details, safety certificates.
A single source of truth.
That's the idea. And eventually, it will be accessible to the public. So a prospective tenant could look up a property on the database before they sign.
That's powerful. You could check safety compliance.
Exactly. And it also helps local authorities target their enforcement against the rogue operators.
And alongside the database, phase 2 brings in the ombudsman. How does that fit in?
The PRS Landlord Ombudsman is for dispute resolution.
The ombudsman offers an alternative.
A way to settle issues. The implementation is staged, though. Setup begins in late 2026, but mandatory membership for landlords is expected later, around 2028.
I noticed in the roadmap that the social rented sector is on a slightly different timeline for Section 21.
That's right. While the private sector leases Section 21 in May 2026, the social rented sector, so say housing associations and councils, will see that abolition in Phase 2, around 2027.
Why the lag?
The logic is that the social sector operates differently and needs a slightly longer lead time to adjust its allocation policies.
Okay, let's look further ahead to phase 3. This is about standards. We've heard about the decent home standard applying to the private sector for the first time.
This is a significant long-term shift. Currently, the decent home standard applies to the social sector. Phase 3 extends this to the private rented sector.
So all homes have to meet a minimum quality.
Yes. Things like being free from serious hazards, having modern facilities.
Well,
But the timeline for this is still TBC in the roadmap. Proposals have suggested full compliance might not be mandatory until 2035 or even 2037.
but there's one standard that seems to be moving faster. Awaab's law.
Yes. Awaab's law sets strict timelines for fixing serious hazards like damp and mold. That will extend to the private sector too. The expectation is it will likely arrive sooner than the full decent homes rollout. It's a priority for safety.
And energy efficiency. EPC targets.
Still a hot topic. The target remains for properties to meet an EPC rating of C by 2030. That's a firm target landlords need to be budgeting for now.
So we have the dates. May 1st, 2026 is the big one. But dates on a page are one thing, making it work is another. Let's talk about the courts.
The big concern.
One of the biggest fears landlords have is that if Section 21 goes, the courts will just get clogged up with Section 8 hearings. Won't the system collapse?
That is the single most valid operational concern, and the government has acknowledged it. You can't funnel that many more cases into an already backlogged system without changing the plumbing.
So what's the plan?
That is why there is a major project underway for court digitization.
What does digitization actually mean here?
It's more than just PDF forms. The aim is a new end-to-end digital service for possession claims. It's intended to guide landlords through the evidence requirements and streamline scheduling. The first release is slated for 2026.
So technology should speed things up to balance the extra volume.
That's the intention. And it's not just tech, it's money. The government allocated $18.2 million in 2025-26, specifically to help local authorities prepare.
Is that enough?
Spread across every council in England. It's a start, but it's arguably thin. This funding is to help councils gear up for their new enforcement duties.
It feels like we are standing on the edge of a complete reset of the rental landscape.
It is the biggest change in a generation. There's no understating that. And while the transition in May might feel intense, the roadmap provides clarity. We're not guessing anymore. We know the dates.
So let's distill this into a final checklist. For our listeners who are trying to get their paperwork in order, where is the guidance and what should they be doing right now?
The guidance for landlords was published back in November 2025, so that's available now. That should be essential reading.
Don't wait until April.
Don't wait. For tenants, specific guidance is due in April 2026. And that all-important information sheet for the transition, that will be published in March 2026.
So landlords need to keep their eyes peeled in March.
Precisely. If you are a landlord or agent, your to-do list is clear. First, read the guidance. Second, watch for the information sheet in March. Third, ensure every single existing tenant receives that sheet by May 31st.
And finally,
Ensure you're not creating any new fixed-term tenancies that extend past the start date without understanding they will convert. Don't set yourself up for a conflict.
sound advice. It's going to be a busy spring for the housing sector.
Indeed. But ultimately, a more professionalized, secure sector should be better for everyone in the long run.
That brings us to the end of this episode of SANDEMY.
We hope this has helped explain how this part of the housing system works and why the changes matter in practice.
This content is provided for general educational purposes only, does not constitute legal advice, and is not published on behalf of any local authority or organization.
For specific situations, always refer to the legislation or official government guidance.
If you'd like to follow the rest of this series, you can subscribe to the channel for future episodes.